way to start your day.
Let's get into that. The president of the Law Society of Kenya is Charles Kanjama, and he joins us this morning. Good morning, Mr. President.
Good morning, and to your viewers, I'm happy to be here.
Karibu sana. Fanya mambo Kinovia. I want to put incoming, but we'll leave that for later. As for what that could be. He is the National Chairman, Association of Certified Mediators in Kenya. Yes. He's also joining us this morning. It's been a minute. Good morning.
Good morning.
Karibu sana.
I'm happy to be here to have a conversation that is very different from politics.
Indeed.
From the things that we always talk about. Today is a very professional conversation.
Oh, of course.
So a very good morning.
One might argue that as we get into it, it likely would shift political, but we'll wait and see how that goes. I'm just very interested in the colors that these two gentlemen have worn today. Very demure, very classic. What did you say? A touch of what? A touch of? Did you say elegance or common sense?
With a touch of common sense.
How lawyers dressed. Yeah. Elegance with a touch of common sense. Yeah. It's interesting to know that both gentlemen are lawyers in the room this morning. So we'll talk about that in just a minute. But let's put you to work because Dennis is in another country this week.
The country we're in is Eritrea. The capital, Asmara, is a UNESCO World Heritage Site and is considered Little Rome due to its architecture. So they gained independence in 1993 after 30 years of war with Ethiopia. Then they became a nation. One thing that stands out as well is if you want proper cyclists, you go to Asmara because they have a cycling culture, and their cyclists actually participate in some of the world athletes when it comes to cycling. But let's go to the proverb. The tongue has no bones. However, it has the capacity to break bones. How would you interpret it, President?
I think it's the power of words. It's an amazing proverb. The tongue has a powerful power because of its the words that utter from the tongue, that they can make lives, they can break lives. The legal profession is one that appreciates tremendously the power of words to persuade and even to destroy.
Mambo, how would you interpret it?
You know, for lawyers, words are their tools of trade. So you can imagine a lawyer without a tongue. I think the tongue has done a lot more than many weapons have done in this country. And you realize that even after, for example, Iran goes to war with the US and with Israel, immediately after they are done, it's going to be resolved by the power of the tongue. It is more powerful than any weapon they have ever made. And I wish sometimes they used the tongue before they used the bombs. Because one thing that makes us unique as human beings is we have language. And language is what makes us more intelligent than any other animal. That you and I can have a conversation. So I think the tongue achieves a lot more. The United Nations is a product of the tongue. Yeah. The League of the Nations was a product of the tongue. And the United Nations has done a lot more than bombs and guns and weapons ever did.
You know, there's something that you said. Perhaps what people need to apply in that tongue is a dash of common sense.
Indeed. Okay. So there's communication that's moving between the Council of Mediators and the Law Society of Kenya. Let's start off with the mediators. Is there a problem, or is it just, let's see how we're going to operate one to the other? But before we get there, can you do the significant difference for us between mediation and mediators and then the lawyers who go into a court of law? Let's set those straight here in terms of what happens when and when can you employ one to the other?
Thank you. I think the first thing we need to understand is that people go to whatever method of dispute resolution because they have a problem. So the beginning point is there's a problem. There's a case, there's an issue, there's a succession, there's a fight, there's a problem.
There's something we couldn't sort.
There's something that we couldn't sort.
Okay.
Now, there are very many methods of dispute resolution. You can have conciliation. You can have arbitration, which basically means you have somebody who is a private judge making a decision on your behalf. You can have mediation. And then you can have litigation, where a lawyer goes before a judge on your behalf and they fight out your case for you. That's litigation. And we even have fighting as a method of dispute resolution. You can choose to fight if you think it's going to resolve your problems.
Okay.
The challenge is that, is it a good method of dispute resolution? Of course it's not. So what has happened over the time, our Constitution 2010, in Article 159 2C, spoke about now the need for the courts to actually implement mediation, to make it possible for people who have a dispute to sit before an impartial third person and just try to agree between themselves. And that's how mediation was born. So the judiciary went full throttle. They started with a pilot, and then they started now a process through which they started getting people and asking themselves, what are the world best practices? The world over, mediators are not necessarily advocates. They can be lawyers, they can be advocates, they can be, from any profession. An engineer can become a mediator. Actually, even a plumber can become a mediator. Only now that for court and next mediation, we set a degree as the minimum. Any degree.
Okay.
The beauty of that is that sometimes there are disputes that we may not have the specific nuances of that place. But somebody who's probably been a critical care nurse and they come into mediation might understand a case of someone who lost their uterus while giving birth, like examples I've had in my office. And they might handle it even better than a lawyer. And so on and so on and so forth. So basically, in a nutshell, people have disputes and people are looking for a way to resolve them.
Okay.
They can go through litigation and find the advocates. There are very many. There are things litigation can do that mediation will never do.
Okay.
And there are things mediation does that litigation is unable to do. And as I finish, I'll just give you one example. When you have a case, for example, of child abuse, you have a father who is abusive to their child. That child needs urgent protection. It can only happen from the courts. So only advocates can do that. They'll take that matter to court. They'll seek under certificate of urgency and say the child's life is at risk. We are asking for court orders. A mediator is not able to do that.
Okay.
But then you have husband and wife who have agreed they are going to live separate lives. And the only conversation they want to have is who will buy Pampers, who will pay school fees, who will pay rent. That one a mediator does very well because it's getting the parties to agree on what their dispute is. So that is the distinction in a nutshell.
Okay.
Yeah.
All right. And how does the Law Society, which is made up of lawyers, advocates, recognize the mediators within the same space?
Let me first answer the first question before we go into the second question. I think it's important to understand the philosophy of law. It is true that human beings have disputes all the time. And some of the disputes are informal disputes. You have disputes as you're interacting with other people, and you need relationships to be built. And the majority of the disputes, people engage in various dispute resolution strategies. Sometimes it's avoidance. They just avoid the dispute or ignore the dispute. Sometimes it's confrontation. Sometimes it's negotiation. We have disputes as friends. We have disputes as business partners, etc. So a moment comes when the dispute becomes something that is connected to the law. So what is the law? The law is the framework that we have established for how we shall arrange our affairs together. It has the rights, the wrongs, the duties, the responsibilities that we all have with one another. So majority of the disputes become formalized when the significance grows and the law comes in. So it's not possible once a dispute has become formalized to resolve the dispute outside the law. Even alternative dispute resolution is resolved within the framework of the law because you need to know the rights and obligations of the parties. For example, you can't resolve a parental dispute by both parents agreeing none of us will take care of the child, because Article 53 of the Constitution gives you a responsibility as the father and the mother, joint responsibility to take care of the child. So the Constitution applies in matters of dispute resolution regardless of the nature of the dispute. The criminal laws apply. So you cannot resolve a dispute by agreeing to commit a criminal offense, for example. So the law applies whether you are resolving the dispute in the court or outside the court. So the role of the lawyer is always central. Once there is a dispute that touches on matters of the law. And the central provision of the Constitution touching on how we shall resolve disputes is actually Article 50, sub-article 1 of the Constitution. And what it says is that every person has the right to have any dispute that can be resolved by the application of law. You remember what I said, application of law. To be decided in a fair and public hearing before a court. So you have a right to go to court, or, if appropriate, another independent and impartial tribunal or body. So the right to be heard in a fair way, apply the law, the Constitution, that one is central to all dispute resolution processes. So what happens when you go to the court is you go before someone who has been trained both in law and in evaluation of facts. You can't become an officer of the court, a magistrate or a judge, before being trained in all that, because you have to evaluate both the facts and the law and make a decision. That is the evaluative kind of dispute resolution. Then alternative dispute resolution is of two kinds. There is evaluative and facilitative. So the evaluative is like arbitration, where instead of going to a judge, you go to an arbitrator who still evaluates as a neutral third party what are the law and the facts of the case and decide the case accordingly. Or you can go to a facilitative dispute resolution mechanism where the parties become the principals in negotiating amongst themselves, and a third party comes to assist them in the negotiation. Even when you do the facilitative process, you still need to pay regard to the facts and the law, even as you are compromising, as you are agreeing, because the law is what we have agreed will govern our lives together. It is the framework that applies. So in answer to the question, what is the difference between lawyers and mediators? First of all, in many countries, majority of mediators are lawyers, for the simple reason that the lawyers are already trained in the law, and they are trained in evaluation of the facts, and they're also very good in facilitating agreement between the parties. But you can't just have lawyers in alternative dispute resolution. So in arbitration, for example, you have other professionals who already are expert in their profession, and then they are trained to understand aspects of the law and of dispute resolution. So the same thing happens with mediation, or ought to happen with mediation. So what the lawyers have been saying is that that is the ideal. But over the course of the last 10 years, as we have been implementing mediation, court-annexed mediation, people have already gone to court. There is a clear legal question. There is a factual question to be determined. The process of facilitation through court-annexed mediation is now broken. It is now suffering, it's leaking, it's suffering significant injury because of the way of implementation, which is what we want to talk about. So we want to make it clear that when you say LSK versus mediators, it gives the impression that lawyers are not mediators. Actually, lawyers are the first and foremost mediators. But they are joined by other professionals who may also come to do mediation in accordance with the approach that the lawyers have formulated and have practiced.
So some of the issues that we see have been raised by LSK is that some mediators operate without clear regulation or professional standards. Mediation may sideline lawyers, affecting legal representation, and complex cases may be oversimplified. So with what our Kili is saying then, should all the caucuses or mediation caucuses, I would call them that, have lawyers embedded in them for these disputes to be solved?
Thank you. I think the first thing that we need to distinguish for our viewer is what is this word lawyer and what is this word advocate? Because you were in a letter changamoto. People ask, so you're a lawyer, you're not an advocate. Now, for our viewer, any person who gets a law degree from a recognized university in the country and abroad is a lawyer. So you have your law degree, you're a lawyer. Now, after that, if you go to the Kenya School of Law, there is a diploma offered by the Kenya School of Law. It's 1.5 years, but your law degree is 4 years. So the substantive part of law is taught at the university. Okay. There's a lot of procedural law that is taught at the Kenya School of Law. So anybody who finishes their law degree is a lawyer. Okay. Then if you go to Kenya School of Law and do the diploma at the Kenya School of Law, and then after that diploma, you apply to join the Law Society of Kenya, where he's president. Now you become an advocate. Okay. And you can go to court. Now, do we have lawyers who are very well learned in law but are not advocates? Yes. Personally, after my law degree, I would go ahead to join the University of Nairobi. And I'm currently pursuing my master's. in constitutional law, democracy and governance. Still in law, an LLM. And God willing, I'll do a PhD in law. But then you become this lawyer who is not an advocate. And Kenyans tend to think that kama hauendi kotini we si wakili.
Okay.
So now what has been happening from his members? Now, people from Machakos, I saw another one from Kisumu, are writing all sorts of letters and telling judges that non-advocate mediators should not be involved in the practice of mediation because hawajui sheria. Some of the members we have at the Mediators, because I'm the chairman of the Association of Certified Mediators, are actually PhD holders in law. Someone comes, they do their first law degree, they finish, they do a master's in law, they finish, they do a PhD in law. That person is lecturing law at some university. They have just chosen not to do the diploma for Kenya School of Law. Okay. And they have chosen not to become advocates. But because those people who are represented by the president here, advocates, feel that only those people who have a diploma from Kenya School of Law and are members of the Law Society of Kenya then are supposed to be in the space of mediation. But we are telling them, let us look at mediation from where it's coming from. When it started in 2016, the success rate in terms of case resolution was 16%. The Chief Justice was with us at Strathmore University just this April when we were just, every year we have a summit for mediation. And she's hailing mediation. The Chief Justice is praising mediation. She's saying court annexed mediation has unlocked 64% of the cases that were sent to them.
And those are some cases that could be in backlog.
Yes.
Okay.
The court annexed mediation has unlocked over 90 billion back into the economy. That is the Chief Justice saying this. There are cases that were 23 years old, 32 years old, which cases were given to people who are not practicing advocates. And those people are able to resolve those cases within 4 days. I have had a 24-year-old case in my office. It had seen enough lawyers, enough judges. It had been through those corridors. Within a short 2 weeks, we were able to resolve that case through mediation. So what we are saying is mediation is beautiful and mediation is working. We are not going to throw the baby plus the bathwater. When you spoke about the manners and the things that advocates are speaking about, si hata mapasta kuna wabaya. We have rogue pastors, okay? We have rogue engineers. We have rogue politicians. We even have rogue advocates, and he will tell you that. In every profession, there will be rogue people. I think that's an enforcement issue. The question we should be having here is, are we having mediators who are ill-behaved? And they are there, because every society will have those. Even priests, we have bad ones and we have the good ones. So the question should be, how do we go about enforcing? By the way, the court annexed, the committee, the Mediation Accreditation Committee, which is the HR arm at the judiciary for mediators, has actually created a code of ethics. We have a code of ethics. For your information, our president, or the president of the Law Society of Kenya, the person who heads that committee is called John Ohaga. John Ohaga is an advocate. He's one of your members. In fact, at the Mediation Accreditation Committee, the organization with the highest representation is the Law Society of Kenya. So all decisions that have been made from the inception of mediation in 2016 to where we are, that committee that has made those decisions has got the highest single most represented organization is the Law Society. It actually has a male representative and a female representative.
Just for clarification, the highest representation of these mediators comes from the
that committee.
That committee
it's
comes from
called
the LSK.
It's called the Mediation Accreditation Committee.
Okay.
Yeah.
At that Mediation Accreditation Committee, and even the committees that formed the pilot from when we are starting mediation to where we are, there is no profession that has got a higher representation in all those committees than the Law Society of Kenya.
Okay.
So all the decisions that have been made, I have told you, in fact, the head of ethics, the person who checks whether mediators are behaving ethically, is called John Ohaga. He's an advocate of the Higher Court of Kenya, and he's been doing an excellent job, because while mediators wana misbehave huwa mimi naambua kama chairman, and we have always told the Mediation Accreditation Committee to deal with them ruthlessly, because we do not want to ruin a very noble profession.
Okay.
So we are working hand in hand with the Law Society of Kenya. It's just that when we started off, actually advocates used to say hawataki mediation. Today we are happy that advocates are saying we want to be the mediators to the exclusion of all others. Yeah.
Okay.
It's like when Uber and Taxify and all the others began. You know, these guys who were driving the old school taxis were saying, hatutaki hizi taxis are up.
Wanachukua biashara
At some
yetu.
point they started to say, sisi ndio tunataka hizi taxis are up, wale wengine wote watolewe. So that's where we are.
So is there a bone of contention, Mr. President, when it then comes to the operation of mediators within this space?
Let me answer broadly, because several issues have been raised. First of all, the difference between a lawyer and an advocate. An advocate is basically a lawyer learned in the practice of law and also regulated as they engage in the practice of law. And that is very important, because every profession must maintain certain standards. You must regulate the code of conduct. You must ensure there's continuing professional development. You must ensure that those members continuously improve their practice and knowledge of the law. So there's a very important distinction. The reason why it is only advocates who are permitted to practice law in Kenya is because they are the ones who have subjected themselves to that process of learning the practical element and then engaging in continuous professional regulation.
Okay.
So that is why our emphasis is on advocates. They are the ones who can represent parties in court. That is something that is recognized world over. So the second thing I would like to say is that unlike the Law Society of Kenya, there is no such thing as a professional body regulating mediators in Kenya. It is not true. It doesn't exist. My colleague's organization of certified mediators is an associative body. It doesn't have any regulatory role. Other people have set up their own bodies, like I don't know, a Patanishi Association. Currently, there are more than 50 bodies that have been set up, all purporting to train mediators, and then after that, they unleash them to the public. What has happened is that when mediation began, the process of mediation training was very well controlled. But this has been liberalized because of the multiple mediation entities that have come up. Some of them are doing things that are amazing. For example, a month ago, one mediation body was purporting to train 1,000 mediators at a go. A tutor has 300 people to train. They train them for 4 days, and then they assume that you are now an expert in mediation.
And you're saying this cannot be?
This cannot be.
Okay.
And that is why we are saying mediation is broken. Once we go beyond the theory into the practice, it is the lawyers who have been attending mediation sessions with their colleagues, with their clients, who are giving horror stories of what they are facing when they go to mediation, coercion of members of the public, to enter into mediation agreements, exclusion of legal representation, people who did not even do the training, but they get certificates, and then they are added onto the mediation accreditation register. The mediation committee has more than 9 members, only two, that is less than 20%, represent the Law Society of Kenya.
Can we take a few
less
steps
than
back?
2? And I can tell you, this is a profession that is not regulated.
Okay.
There's a code of ethics in theory, but there's no one to implement it. The Mediation Accreditation Committee doesn't have the capacity. That's why we are saying mediation is broken in Kenya today.
My question is,
and the lawyers at the front line are the ones who are sharing the horror story. So we've said we need to fix it.
Mr. President,
let's first confront the reality that there is a problem.
Let's take a few steps back and understand the genesis that allowed mediation as an alternate dispute resolution mechanism. That somebody allowed this to happen. Somebody said that mediation is a source that can be used. The numbers that Fanya Mambo talks about this morning are actually true.
Let me tell you. Let me tell you. You said the numbers are true. You don't know whether the numbers are true.
If you allow me to finish the statement, and then I can ask the question.
Yes.
The Chief Justice gave out these numbers, and that we see that she said of the money that has been unlocked as a result of mediation as a tool.
Let me tell you.
Allow me to finish the
because you are making several statements
because
that
I am
factual.
I am leading to a question. So if you just
Even
allow
your
me,
statements
the president,
are presuming
excuse me,
something.
The president of the Law Society of Kenya is you.
Yes, yes.
The Chief Justice is the president of the judiciary. At an event, she said, let me put it that way so that I can ask the question. She said that a certain amount of money has been unlocked as a result of mediation. She said that some cases which had been locked up in back and forth for decades had been released now because of mediation. Is that better? She said this.
Yes.
My question is, what is the genesis of then allowing mediation as a mechanism of alternate dispute resolution? Who said in the beginning that, you know what, we can use this, we can use arbitration, or we can use the old-time duel where we take 10 steps and somebody turns around and shoots a pistol? Who said that we can use this? And what were the mechanisms under which this was then established? Perhaps we can get somewhere if we understand where this thing started from in the first place.
Yeah, I'll answer that. But let me first answer the facts you've stated. If I go to court and I have a dispute worth 3 billion shillings, one dispute, and then we go to mediation in a process that involves lawyers and the parties, they discuss and they agree, that one dispute will have released 3 billion into the economy. So when you use financial terms, it doesn't tell you anything about the number of disputes.
Okay.
It just tells you about the value. So you have a few high-value disputes, and they help resolve matters into the economy. And those high-value disputes that have been there are the ones which go fully in accordance with the intendment of mediation. The lawyers are present, the parties are there, the stakes are high, everything is done properly. I personally have been involved in mediation. I'm a quarter-next mediator, involving disputes relating to banks and customers. One dispute that I was involved in released about 1 billion shillings into the economy. One dispute that Charles Kanjama, as a quarter-next mediator, was involved in. So we have to distinguish between the value of specific claims and the number of the claims. What we are saying is that now, right now, the experience is that the vast number of mediation matters, there are things that are happening there that are contrary to the intention of the Constitution. Now, to answer your question about where mediation comes from, it is precisely a dispute resolvers like lawyers who, when we were drafting the Constitution, and as you know, the Constitution was drafted by lawyers in accordance with the views of the public, but it's the lawyers who drafted it. We put there, under Article 159(2)(c), reference to alternative forms of dispute resolution. Even the Constitution recognizes traditional dispute resolution. We realize that disputes will not only be solved through the formal courts. We also recognize tribunals, because we said even in the formal process, it's not only the courts. You also need to go to tribunals, rent tribunal, tax tribunal, etc. So we are trying to make justice accessible to all. But in the process of making justice accessible to all, we did not exclude the application of the law.
Okay.
That's the important issue. The law still has to be applied in the process.
And are you saying
If
that
I
in the
would say-
processes that mediation is not allowing that inclusion of the law to
Actually,
happen?
That is, let me finish. That is actually what has been happening in many cases. You
Okay.
see, one of the advantages I have is I've just come from an electoral cycle where I had to go around the country, meet lawyers, talk to them, ask for their views, listen to the experiences on what has been happening in practice. And one of the common areas of complaint has been mediation. And actually they charged us as the current LSK council, when you come into office, please fix this issue that is mediation.
Lawyers are saying this.
Yes, because they are the ones who, they are the single profession that is most involved in mediation, because they go there with their client. Sometimes they're excluded from the mediation. Sometimes they see their clients being coerced into signing mediation agreements. Sometimes they see mediators who have very little training, very little ability to do what is meant to be done, purporting to engage in mediation. So they've told us, fix it. And for us, we are saying that we can't afford to bury our head in the sand. Mediation, court annexed mediation, currently is broken in certain issues.
Fanyamambo,
No. Actually,
Fanyamambo, I want to look at the Mediation Accreditations Committee, right?
Yes.
And I want to look at that being the HR body for the mediators, right?
Yes.
And the laws that govern the mediation processes as per the law.
yes.
What laws or regulations are there, and who does Mediation Accreditations Committee report to or answer to? Who regulates them?
To start with, right now, Justice Odunga is in charge at that place. And let me tell you, you cannot have the case of the pot calling the kettle black. When I hear the president of the Law Society of Kenya speaking of mediators putting clients through horror stories, if Kenyans were to come here and tell you what they've gone through at the hands of advocates, I think you would see that mediators have been heaven compared to what they've gone through at the hands of the people he represents. Mediators have done really well. We've tried where things have failed. By the way, ask yourself, who sends cases to mediation? Judges. A person who, for you to qualify to be a judge, you have to have served for 15 years as an advocate. Now, you served for 15 years and then you probably practiced as a judge for 10 years. A person of 25 years experience sitting at that bench and looking at the monkey games that some advocates are playing in court and deciding this case must go to mediation. And then a 23-year-old case is resolved in 4 sessions. Do you think that judge was wrong? So when you come here and say that those cases went well because advocates were involved, they also went horribly because advocates were involved. And they were with that case for 24 years. And they were playing monkey business with it. Let me tell you a story that something that came to my office some time back. We train a young lady, and because Kilimani Mediation Center, my firm does train people in mediation. The other thing that I want to address, and she goes to her dad's law firm and tells the dad, "Dad, I have these special skills." But they love Gen Zs. They're amazing people. And she tells the dad, "I can resolve any case in this firm." And the dad tells her, "Try this file." It was a 17-year-old succession dispute. And God helps her. In 2 months, it's resolved. Then she comes and says, "Daddy, I've made it." The dad looks at her and tells her, "Wewe ni mjinga sana. Hii file imekusomesha, imesomesha brother yako high school, na nilikuwa napanga isomeshe mtoto wenyu mdogo amalize nayo university. Sasa wewe umeenda kuimaliza within 2 months." These are the stories of what advocates have put people through that they also don't want us to have a conversation about.
If I was to
So
open
let
that
me-
up
let
just
me
a little
come
bit,
there.
Fanya, are you saying that mediation is a loss of revenue to advocates, and that's why the
These are
issue might
people
be
are just
coming up?
feeling threatened. And just the way I told you, like when Uber came and people were thinking now, because we are used to the old taxi method of dropping somebody here, unarudi mpaka mahali ati tuko na shimo yetu kama taxis. The justice space is going to change and they have to be prepared for it. But let me continue prosecuting my point. He spoke about training and he spoke about people just waking up and training people and releasing 1,000 people. We would like to know which institution is this that got 1,000 people to train in mediation, because that would be phenomenal. It doesn't happen.
It was
What
last
the
month.
judiciary did, the judiciary is very responsible. Let me first defend the judiciary, in as much as I'm not a servant of the court as he is. The judiciary first took, I remember the first batch of 60 of us to Strathmore University. And I must thank Strathmore University for presenting that opportunity. They brought people from the ADR Institute of Italy. They brought people from the United States, and we were trained continuously for 3 months at Strathmore University on how to train people to become mediators.
Okay.
The ADR Institute of Italy is not a joke of an institution that will just give you a fake certificate because you've been trained in mediation. Some of us have trained very many. I train advocates. Every other month I have a training. And when they go back, they give value to their profession and they are grateful and they say it. When these people are becoming mediators, they don't just become mediators. They go to an interviewing panel. They find judges. And most of the times, I love Justice Odunga. He's hands-on. He's one of the persons you'll find there and he'll ask you very hard questions. You don't qualify, you don't become a mediator. You qualify, you become a mediator. There's only one place I agree with him. That like every other profession, mediation has got its challenges. We have a few rogue mediators, but these figures are speaking for themselves. We have a few rogue advocates. We have a few rogue pastors. That will happen. And I think this is a question of how do we regulate? He's spoken about associations. What has happened is just like him. The people in Kisii have got their own association of mediators. It is closer for them to be able to have their own problems. But at the national level, this is what we are doing. Now, are we unregulated? No. We have an ADR bill that we have been trying to push. Hata sasa ndio maana nataka niingie your parliament by the next year. Because this ADR bill needs to go through and we want mediation properly regulated. For now, the code of ethics is there. The implementers of the code of ethics for mediators are your members. In fact, the chairman, I told you, the person in charge of seeing to it that mediators behave is an advocate. You are the president. Talk to him, ask him. Ni wapi shida iko? And if there's a place we can collaborate and cooperate, we are happy to. Finally, the president comes and talks of that there was one case of 3 billion. The Chief Justice, who is the president of the courts in Kenya, comes and says that since we began mediation, 24,464 cases have been sent to mediation and they have been resolved successfully.
All of the 24,000?
Yes, no. They sent 40,000, but 24,000, which represent a 64% success rate. This was at Strathmore this April. 24,464 cases have been resolved successfully. And these cases on their own unlocked 68.9 billion into the economy. So it's the 24,000 cases that unlocked 68 billion into the economy. Also, this mediation has been expanded to 120 registries. When we started, there was only one in Nairobi. But the courts themselves started seeing the benefits of having mediation, and they started making sure they are increasing the registries. Now, around the country in 47 counties, we have 120 registries that are picking up cases that some of them the judges have looked at and said, others the judges have seen, amana hapa mawakili wanachezea watu. They've been sent to mediation and they've been resolved. Most finally, the Chief Justice said that out of the people who have disputes in this country, only 10% go to court. People keep speaking about court annexed mediation. They forget that we have other cases. 90% of the cases in this country don't go to court. We have so many other cases that are out here, and that is what is encouraging private mediation. In my farm, Kilimani Mediation Center, I'm always sitting and entertaining private matters. People who went into business transactions that didn't go well, and they come to me, I own a petrol station, this person has got 40 lorries, they owe me 2.6 million, we sit down, we agree. We file those private mediation settlement agreements in court. It's a procedure provided for by the courts and they become law. And let me tell you, Mr. President, I want to encourage you because next year you will be my president. I decided this thing of kushinda hapa tukisumbuana. I am actually a student at the Kenya School of Law this time as we speak. And so next year you will be my president. So I speak as someone who has got a very strong inclination to mediation, but at the same time, I'm a trained lawyer. And I felt that if this only step of becoming an advocate is the thing that makes us look like we are saying this because we are not advocates. Now we are telling you, we are saying this as people who are both passionate about mediation, passionate about law, and yes, strongly committed to justice. Because these are justice stories. This is someone who has a problem that they wish was resolved in any way as long as it gives them justice.
I think, allow me to respond on several issues that have been raised. I think the first thing that Fanyamambo has done is he's tried to reflect on the question of criticism to mediation and said that actually it is lawyers who are messing up the legal justice system. First of all, I'd like to tell him that even those judges that are sitting in the courts are lawyers. Those judges that are recommending matters to mediation are lawyers. Those judges that are receiving mediation settlement agreement are lawyers. Lawyers are the ones who are most keen in getting disputes resolved. Secondly, Fanya Mambo says that lawyers are fearing that they are going to lose legal fees or work. Lawyers are the ones who suffer greatest with their clients when there is delay in resolution of disputes. And it is not true that when you resolve a dispute through mediation, the lawyer loses their fees. Actually, they get their fees faster. The lawyers are the greatest champion of alternative dispute resolution that can be speedy. It is not because they are losing their fees. They are getting their fees. So by the time the lawyers come and they start complaining about processes, accelerated mechanisms in mediation, which are meant to help them get their fees faster, you then know there is a serious problem. And this serious problem has been developing over time. And I can tell you, if we start discussing issues about buildings that are collapsing in Kenya, we start saying that building standards are not very good, who do we go and talk to? We go and talk to the professionals who come up with those buildings, the architects, the engineers, the QSs, because they've been trained, they are regulated. We ask them, what is wrong with this issue? Can't you resolve it as a professional body? If we start hearing that doctors are engaged in malpractice or medical professionals, who do we go to? We go to the professional body. Because it's regulated, we expect more of them. So that is why when there are issues with mediation, we have to go to the people who are regulated, who are the professionals, the lawyers. They're the ones who are regulated. The mediators, unfortunately, are meant to be regulated, but the structure that is in existence does not regulate them. Because the Mediation Accreditation Committee, which is an organ of the judiciary, their main role is to accredit, and after accrediting, to give work. The process of providing complaints and so on has not yet been established effectively.
Has it been raised?
Yeah.
Has it been raised as an issue?
My members have been raising all manner of concerns about mediation. Right now, we are collating the information that they're sharing with us. They have already shared quite a bit over the last 10 days in social media and other platforms of lawyers. And when I tell you they are horror stories, they are horror stories.
What are some of the issues that come out as a problem? Because if we understand that, because like, for example, you know, some of the things that we see come out, people complain about lawyers negotiating without their information, and, you know, fees and things like that are gobbled up. What are some of the things that we hear on the side of mediators that would then pose the problem that you talk about concerning regulation?
Yeah, so first of all, let me talk about lawyers. When there are complaints against lawyers, we have a body under the Attorney General's office. It's called the Advocates Complaints Commission. You go there, you lodge your complaint. We have a body called the Advocates Disciplinary Tribunal that deals with complaints against advocates. And they receive numerous complaints, they process them. And in fact, one of the commitments I made is to ensure that this process is faster. This has not been happening in the case of mediation effectively. Why? Because the judiciary is not designed to be the professional regulator of any profession. You come up with professional regulatory arrangements outside the judiciary. The judiciary's role is to resolve disputes. So that is why there's a major gap. And what we have found is that we've actually done quite a bit of benchmarking with other countries. We found that all the significant countries, I'll give examples like Nigeria in Africa, there's always a strong involvement of the legal profession in the question of court-annexed mediation or regulation of court-annexed mediation. Globally, in countries like Singapore, France, Denmark, we've seen the same thing happening in several states in the United States, in China, Japan. So we've actually done benchmarking. And these are things that we are going to be proposing to the judiciary when we meet them very soon, because we want to find solutions. It's not just a blame game. We need to find solutions. And one of the solutions is there needs to be tighter regulation of these numerous bodies that have now sprouted up, all purporting to offer mediation. They go with a certificate saying we've trained for 40 hours. There's nobody to verify because there's nobody from the regulator to attend that training of that institution. You can't even compare what is being done there with what Commission of University Education does with the universities, or TVET Authority does with TVET institutions. It's a very kind of like Wild West in the question of mediation training. They come with a certificate. Nobody was there to confirm that they've done the job. Nobody went, just a moment, let me finish. Nobody went to verify that this particular institution is training in this particular place and so on. One of the issues that has happened is I have actually been told by one of the very established mediators himself. He's talked to me personally. He's told me, Kanjama, we have a problem in mediation. And he leads a very respected mediation institution. Very respected. That was there from the beginning. Before Fanyamambo was trained, they were there training. He told me, Kanjama, we have a problem in mediation. He's the one who told me that just last month, there's an institution I can't mention on radio because they are not here, that was training 1,000 mediators. One tutor's training 300. He told me, Kanjama, you are right. LSK is right. There's a problem. I've received this information from very expert mediators, lawyers and non-lawyers, who are telling me there's a problem. It's good what the Law Society of Kenya is doing. It is high time we deal with the issue. Yeah. So we can't afford to window dress the problem. We have to confront it and resolve it. That's what LSK wants to do.
The question then, Fanyamambo, you've mentioned about the ADR bill that is in Parliament, and for some weird reason is not moving. One would also ask LSK, knowing very well that this bill is there and seeks to bring forth the regulations and the sanity that you seek.
I'll tell you what happens to that bill.
How are you pushing that as well? As LSK, and then you'll respond to that.
So for us, at least my council has come into office in the last 1 month, and we are taking a very kind of like systematic approach to deal with the space of mediation and also arbitration and other dispute resolution. We are engaging stakeholders in the ADR space. We've already engaged a number of them. We are engaging the judiciary. We are collecting data. We are doing fresh review to look at the philosophy and architecture of the bill so that it can be improved and made fit for purpose, and that it can take into account the gaps that have been there in the practice of mediation, because we are talking about court annexed mediation right now, including the need to re-emphasize the primacy of Article 50 of the Constitution and the fact that alternative dispute resolution does not mean dispute resolution contrary to the law. The law still remains a foundation of dispute resolution because it's a foundation of our legal rights and relationships. That's what we are trying to do. So we are basically saying that we'll have a solution. Kenyans need not worry, we'll have a solution. LSK is a very responsible interlocutor in the matter. We're also going to engage a few other professional bodies that have a lot of interest, for example, in arbitration, like the Architecture Association of Kenya, the architects, the engineers, etc. So we are going to come up with a solution. But we are saying that as we do so, we need to adopt the professional discipline that works in all the areas of provision of services of a high standard that impact on lives and welfare of Kenyans.
Fanyamambo,
what's
up with the bill?
That's what I actually wanted to explain to you here. In 2022, this bill was doing very well. In fact, we thought it was going to pass. And he knows because he was a member of the Law Society of Kenya. And if he was not the president, he was a member. Hao ndio walikuwa wa kwanza kuipinga. And the reason they fought it that time, there was a provision in that bill that specifically said that before any matter is filed in court, it has to first go through ADR, and then if it fails ADR, it goes to court. The advocates did not want that particular clause. So it was thrown out specifically because of that clause. And then it's not had, there's no member of parliament who found it as a necessary bill to push it all the way. So the key issue, that was mainly, it was actually the Law Society of Kenya that they said, Apana, you cannot have a law that allows us to, must go through mediation. We just want to go to court direct. Because that's where they thrive in keeping you there for 3.5 years.
Who thrives?
By the way, the advocates, I can tell you, again, the Chief Justice speaks about it, The target is 60 days within which we are supposed to resolve mediation disputes. She says the average of dispute resolution in mediation is 74 days. The average of dispute resolution in their court process is 3.5 years. If you're a Kenyan, where would you go to? Would you rather resolve your dispute in 3.5 years or within 74 days? And these are numbers. I love the fact that they come from the Chief Justice herself, because this information she's fed with from her own courts. And her courts are telling her mediation is a success story. Why do you have fewer registries? Open up more. As we speak, the judiciary is actually trying to roll up more registries to increase the number of mediators, to increase the number of cases that are being allocated to mediation, because there's no other place you come and speak of 91% success rates. There's no other place you come and speak of 64%. There's no other place you can come and speak of such figures. There's no other place you can speak of 74 days. 74 days for a court case, other than small claims, bado mko kwa mentions. Hata mjafika substantive hearing, mko kwa pre-trial, mko kwa mentions. You are still trying to decide how you're going to go about the case within 74 days. During that time, a mediator, done, dusted, they're on the second, third, fourth case. I think there's only one thing we need to agree on with the Law Society of Kenya. Mediation is here to stay. In fact, mediators are going to increase. If anything, we are going to fight to make sure that mediation grows. It is now upon the Law Society of Kenya to agree together with us that we need to take the ADR bill to Parliament. We need to sit together as stakeholders and say, we are all in this space. What do we put in this ADR bill? And what do we remove from this ADR bill? How do we make sure that mediation becomes a success? In terms of training, again, I tell him, there are 2 members of the Law Society of Kenya who sit at the Mediation Accreditation Committee. They have given a list of those institutions that have been allowed to train mediation in the country. They are about 35, 36 thereabout. Hawajafika hizo 50 nasikia. And also, in our training regulations, a class is not supposed to have more than 25 people. In fact, we've been in that space. I've been advertising my classes. I even have a class coming up next month. You'll struggle to get 25 people who can pay that amount of money to get the kind of training we are doing. So you'll probably have a class of 10, 15, 12, thereabout, on average. So when I hear somebody has 1,000 people and they're teaching them mediation,
Even you are shocked.
it is too ambitious. It is too ambitious. Yeah. So all I would like to say is, let me tell you, President, we are together in this ship, and we have to find a way to make sure that it works.
Well, I think that's the word.
I need to answer. It's very important.
I hear what you're saying.
It's very important.
We can regulate, Mr. President. We need to regulate the time here as well. Okay, so I can give you 10 seconds to do that.
10 seconds after all that he has said.
You've used 3.
You are going to leave your viewers with some issues that
go ahead, Mr. President.
So the first thing I want to say is that it is quite unfortunate to assume that Kenyans who go to the courts after they have made various attempts to resolve their disputes have gone to the courts casually. That they have gone to the courts because they don't realize it is the last option. That when they go to court because they're exercising their right under Article 50 of the Constitution to get access to the courts, they don't know what they are doing. So there are 2 underlying basic principles that underlie dispute resolution. The first is Article 50, that says everyone has a right of access to the courts. The courts cannot turn you away. And by the time people are going to the courts, they have tried everything else. It has not failed. They want the courts to be involved. And even if the courts take them to mediation, they want the courts to be involved in the process. Number 2 is that a fundamental principle in authoritative dispute resolution, including mediation, is what is called party autonomy. It means the parties have a right to decide for themselves. And the parties are advised by lawyers. You can't force parties to go to a process that they don't want. You can't turn mediation into another court whereby the mediator forces you to make determination that you're not willing to make, or that you take away. You lose several of your rights that you had. So of course, as lawyers, we support alternative dispute resolution. What we are saying is that there are areas in court annexed mediation that are broken and that we need to fix.
Well, that's something that I think both of you can agree on in terms of what needs to be fixed, should be fixed. But I think you're both saying at some point that this will continue and that we'll get to the place whereby the process will continue and that everybody can agree that what needs to be fixed will be fixed. The
Tutalimana
president-
mpaka tuelewane.
Okay, that's another way to look at it. Like we said, the president of the Law Society of Kenya is Charles Kanjama, and also Fanya Mambo Kinovia is the national chairman of the Association of Certified Mediators in Kenya. We've got to say goodbye at this point. Thank you both for being here at 9:02. Good morning.
This is the Situation Room, the only way to start your day.